reserving 1 minute for rebuttals. If your lordships are well versed with the facts of the case, the counsel would like to proceed with the arguments.
Yes.
Much
Proceed
obliged,
with the
Lord.
arguments. We are aware about the first one.
Much obliged, lordships. Lordships, to deal with issue number 1, the counsel would be submitting the same in particularly 3 sublimits. Firstly, regarding the maintainability of the SLP under Article 136. Secondly, regarding the perverse nature of the trial court's findings. And thirdly, regarding the hidden role of Neurolytics Private Limited and the constitutional violations arising out of the same. Lordships, to deal with the first limb of the argument regarding the maintainability of the SLP, the counsel submits it in affirmation that the present SLP is maintainable both on substantive as well as procedural grounds. Lordships, to deal with the procedural limb of the argument, the counsel submits that Article 136 is a wide provision in law and reads as follows: that a special leave to appeal may arise out of any judgment, decree, final order of any court. Lordships, the terms any court in the humble and respectful submission of the petitioners must be interpreted literally. And hence, Lordship, the same is also the set position of law in this regard. And wherein in the case of B. Premanand versus Mohan Koikal, it was held that where the language of the constitution is unambiguous, it must be interpreted literally. And that is the submission of the petitioners in the instant case, that the terms any court must be interpreted literally. And hence, the trial court's judgment can well be challenged before this honorable court via the route of Article 136. Lordships, furthermore, the trial court's judgment raises serious questions which are substantial in nature and are unsettled as well. Lordship, since neural rights is an emerging field in law and the jurisprudence around the same is not settled, it needs a conclusive and authoritative interpretation by this honorable court, Lordships. Furthermore, Lordships, it would not be an unprecedented first when this honorable court considers a SLP arising straight out of a trial court's judgment. Lordships, in the cases such as Rajendra Kumar Jain versus the state through special police, it was seen that a special leave petition was admitted by this honorable court, which arose from a trial court's judgment, Lordships. Lordships, moving to the second limb of the argument regarding the perverse nature of the trial court's ruling, it is humbly submitted, Lordships, that the trial court relied on irrelevant and baseless grounds in order to deny the PMS-related defense of the petitioner. Lordships, that for one instance, the trial court relied on the professional achievements of the petitioners in the instant case in order to deny the PMS defense. Lordships, which is completely a gender-insensitive take on the entire issue in itself. This would further be substantiated by my co-speaker at length as well, Lordships. Lordships, in the case of Dayabai Chhaganbhai Thakkar versus the state of Gujarat, this honorable court drew a distinction between permanent insanity and temporary insanity. Lordships, this very distinction, the learned trial court failed to draw in the instant case. Lordships, had the distinction between permanent insanity and temporary insanity been drawn by the learned trial court, the PMS defense of the petitioners could have squarely fallen within the ambit of temporary insanity, thereby allowing the said defense, Lordships. Furthermore, Lordships, in the case of Preetham Singh versus the state, it was held that an SLP can be admitted to correct manifest injustices visible on the face of record. Lordships, in the humble submission of the petitioners, it is submitted that the instant case involves manifest injustices which are rather very much visible on the face of record, and hence the present SLP is due to be admitted by this honorable court. Lordships, moving to the third limb of the argument regarding the systematic and the procedural misconducts involved in the instant case, it is humbly submitted, Lordships, that the instant case involves a private firm, Neurolytics Private Limited, which is a private firm, Lordships. Lordships, this very private firm acted suo moto to label the petitioner's conduct as aggressive. Lordships, it is pertinent to also mention that the same private firm failed to analyze the NID data of the deceased in the instant case. Lordships, had the NID data of the deceased in the instant case been analyzed by this private firm, there could have been noteworthy revelations which could have been brought forth for this honorable court's consideration, Lordships, which the private firm completely failed to do. Lordships, this selective procedural misconduct of the private firm completely raises question of potential biases, Lordships. And Lordships, in such a situation, a retrial is necessary. And the same was held in the case of Muhammad Hussain versus State Delhi Administration, wherein it was held that suppression of material evidence is a ground for retrial and full disclosure is essential for effective defense. Lordships, the Neurolytics Private Limited's role only came to be known to the petitioner's attention post-trial, Lordships, and thus serving as suppression of material evidence at the trial stage. wherein the petitioners did not have any sufficient opportunity to cross-examine the experts of the Neurolytics Private Limited at the trial stage itself, lordships, thereby also violating the fair trial standards under Article 14, which would be dealt by the council under issue 4 at length, lordship. Lordships, lastly, submitting regarding this issue, the chain of custody of the NID data in itself is very much unknown. Lordships, the chain of custody requirements as per the evidence, as per the evidentiary standards, is an essential, lordships. And if the chain of custody of a particular evidence is not known, that evidence cannot hold good in law, lordships. That is a humble and respectful submission of the petitioners in the instant case. Furthermore, lordships, if your lordships are satisfied with the arguments in issue 1, the council would like to proceed with issue number 4.
Please.
Much obliged, your lordships. Lordships, to deal with issue number 4, the council would be submitting the same in 3 sublims. Firstly, regarding the violation of the right to fair trial under Article 14. Secondly, regarding the breach of autonomy under the DNRA Act. And thirdly, lordships, regarding the culminative effect of the due process and judicial independence. Lordships, to deal with the first limb of the argument regarding Article 14's fair trial standards, it is humbly submitted, lordships, that Article 14 provides for procedural fairness, which must be free from arbitrary state action. And that has been the position of law, and this honorable court has conclusively held it in cases such as E.P. Royappa and Menaka Gandhi, lordships. Lordships, the respondents in the instant case heavily relied on the Neurolytics Private Limited's findings, thereby providing no opportunity to the petitioners in the instant case to cross-examine the experts of Neurolytics at the trial stage itself, lordships. Thereby, the petitioners were not provided a level playing field at the trial stage itself, lordships. To deal with the second name of the argument, lordships, regarding the Neurolytics involvement violating the statutory rights under the DNRA Act, lordships, it is humbly submitted that the DNRA Act explicitly protects and preserves an individual's mental privacy and autonomy. Under Section 8 of the said Act, lordships, access to NID data can only happen after explicit consent of the data holder. Lordship, this explicit consent in the instant case was not taken in itself. Lordship, the petitioner did not consent to the use of her NID data, which was later on made a evidence against herself, thereby violating the right against self-incrimination under Article 20 Clause 3, which would be dealt by my co-speaker at length. Lordships, in the case of Ram Jethmalani versus the Union of India, it was held that informational privacy and human dignity are two inseparable components. Lordships, these two inseparable components have been separated by the respondents in the instant case. Furthermore, Lordship, the Council concedes to the fact that under Section 12 of the DNRA Act, an exception as to exigent circumstances is provided. But, Lordships, the same must also be done with due judicial oversight. Lordships, which was not the case in the present matter. The due judicial oversight requirement was not met by the respondents in the instant case, thereby violating the right to fair trial under Article 14, and also the statutory rights under the DNRA Act have been violated. Lordships, regarding the last limb of the argument, regarding the culminative impact of these violations, it is humbly submitted, Lordships, that the culminative impact of these violations is rather devastating, as it brings forth deep-rooted connections between the state and Neurolytics Private Limited, which is a private firm, Lordships, thereby tainting the credibility of the evidence and questioning the judicial independence to a very great extent. Lordships, in the case of A.R. Antule versus R.S. Nayak, it was held that even minor irregularities benefit the accused. Lordship, it is the humble submission of the petitioners that in the instant case, the irregularities are not minor in any manner whatsoever, but they are rather systemic, which strike at the very core of the issue in itself, Lordship. The public-private nexus hampers the fairness and accountability standards, Lordship, thereby turning justice into a mechanical procedure wherein the case is already pre-decided against the petitioners in the instant case, Lordship, before the even beginning of the trial. Furthermore, Lordship, in conclusion, the Council submits that secrecy and lack of transparency cannot coexist with the constitutional ideals of fairness and due process. And hence, Lordships, in light of these arguments, just concluding remarks, Lordship, if your Lordship permit.
Please.
Much obliged, Lordships. Lordships, in light of the aforementioned arguments, the Council humbly submits, Lordships, that the present SLP is maintainable both on procedural as well as substantive grounds. And secondly, Lordships, that the fairness requirements under Article 14 have not been duly met by the respondents. And in light of the same, Lordships, the trial court's judgment is bound to be overruled, Lordships, by this honorable court. It was an honor to argue before this bench.
So speaker number two is going to you can start
Much
now.
obliged. Much obliged, Lordship. Lordship, this is counsel number two on behalf of the petitioners, and the council will be dealing with issue number two and three in the present case. Starting with issue number two, Lordship, the council will be dealing with the issue in three limbs. Firstly, that the burden of proof under section 108 of the BSA is discharged in the present case. Secondly, that PMS supported by medical evidence fulfills the requirement under section 84 of the Lexlandian Penal Code. And thirdly, that the actions of the accused after the commission do not disprove insanity in the present case. Lordship, moving on with the first limb of the argument, it is submitted that the burden of proof under section 108 of the BSA, it is discharged if there is a reasonable existence of any possibility of unsoundness of mind. Lordship, according to this section, the accused need not conclusively prove insanity, but raising mere reasonable doubts on the mens rea by any medical or any circumstantial evidence, it's sufficient enough to shift the burden back to the prosecution, Lordship. In the case of Dhannaram versus State of Haryana, Lordship, the court held that even if insufficient material is there, it is enough to discharge section 108 of the BSA, and the burden raises doubt on the mens rea and extends the benefit of doubt, thus making out of the case for the accused. In the case of Dayabai Chhaganbhai Thakkar versus State of Gujarat, Lordship, the court has the power to acquit if there has been reasonable doubts raised on the mens rea of the accused, and hence section 108 of the BSA will be discharged and the court is entitled to give acquittal, Lordship. Now, Lordship, this reasonable doubt that the council is talking about, it will be raised by the council in the further submissions, which will discharge section 108 and even warrant an acquittal of the accused in the present case. Starting with the second limb of the argument, Lordship, it is submitted that Section 84 of the Lexlandian Penal Code clearly establishes that for the defense of unsoundness of mind, it is pertinent to prove that the accused was incapable of knowing the nature and consequences of his or her acts. Now, Lordship, PMS is a common condition that affects many women of reproductive age, which includes severe anxiety and emotional dysregulation. And the same has been substantiated by various medical reports as well as journals, which have been relied upon by this very honorable court in the past judgments. Lordship, in the present case, the medical records and the NID data confirm high amygdala activity as well as increasing cortisol level, which are indicative of acute stress and emotional strain, which align with my client's documented PMS symptoms. Now, Lordship, this hormonal and neurological imbalance rendered her temporarily incapable of any rational judgment or control that meets the criteria for Section 84 for unsoundness of mind, because it impaired the ability to know the nature of wrongfulness of the act during such an episode. Now, Lordship, furthermore, in the case of R versus McNaughton, this landmark case law gave us three rules to determine the unsoundness of mind, Lordship. Firstly, not knowing the nature of the act, Lordship. The accused in the present case did not know the nature and consequences of the act, Lordship, and because of the same reason, actus reus, that is the guilty act, because it will not apply in the present case because the physical act itself was not voluntary in nature because of the increasing cortisol level, which put the woman's body in a fight or flight response. Secondly, Lordship, not knowing the act was right or wrong. Since, Lordship, my accused was not in the right state of mind due to her triggering of PMS. She did not know whether the act she was committing was indeed in violation of the law or not. And thirdly, defect of any reason from the disease of mind. Lordship, this is a foundational prerequisite because the incapacity must be due to a cognitive impairment that is caused by the unsoundness of mind. This establishes, Lordship, a legal and not merely a medical standard for excusing the accused in the criminal conduct. Lordship, furthermore, the case of Regina versus Craddock, the court accepted the defense of PMS and held that PMS can be a valid ground under the under the provisions of unsoundness of mind or insanity, Lordship. And finally, Lordship, it is finally submitted that till this date in this country, only one single case has been adjudged regarding PMS as a valid ground, and that is case of Kumari Chandra versus State of Rajasthan, where the court accepted the defense of PMS as valid ground under Section 84 of the Penal Code and acquitted the accused who pushed three children into a well during a PMS episode, Lordship. It noted that the defense that at the time of incident she was suffering from unsoundness of mind due to PMS is completely falling under the Section 84 exception, Lordship. Moving on with the last limb of the argument, Lordship, it is submitted that the actions of the accused after the commission of the offense does not disapprove insanity, Lordship. it is submitted that the critical focus is the accused mental state at the instant time of the offense, and actions like fleeing the scene or committing the crime in broad daylight do not disprove temporary unsoundness. And the same was held in the case of Shirali Wali Mohammed versus State of Maharashtra, as well as Shrikant Anandrao Bhosle versus State of Maharashtra, where this honorable court ruled that factors like fleeing the scene or committing the act in broad daylight, these things do not necessarily disprove insanity, lordship, which means that it can't be always a factor that the accused was aware of what she was doing and leading to the acquittal of the accused in the present case. The mere fact that Arohi left the crime scene after the commission of the act, lordship, it does not disapprove insanity due to these above two judgments, lordship. If your lordship are satisfied with issue number 2, the council seeks permission to go ahead with issue number 3.
I have a small question, counsel.
Indeed,
So
your ladyship.
Section 84 requires the accused to be incapable of knowing the nature of the wrongfulness of the act. Are you saying
Indeed.
that stress induced via PMS meets that particular threshold?
Indeed, ladyship, the council submits that the section 84 clearly states that the accused should not be should be unaware of the act that he is committing, and the council is also submitting that PMS, due to medical reports and due to the fact stated, the increasing cortisol level and the amygdala activity, your ladyship, this increased the strain level and it resulted in acute stress for the accused, your ladyship, and that's why she did not know what she was doing because it rendered her incapable of any reasoning, your ladyship.
Okay,
No, it
please.
is not for the very first time that she probably got through this particular phase. So eventually, you are trying to say that whenever she's into this phase, she can pick up anything, throw it to someone else, kill someone else, and take a plea of this.
Indeed, not your lordship. The council do not is not contending that at every PMS episode of the accused she is in such a physical state. But your lordship, it should also be noted by this court that the actions of the victim are very important in this present case, your lordship, because of the victim tried because of the victim's actions, it put the accused in such a condition that she had to respond in such a way. Lordship, this is not a general day of conduct in which a man puts himself in a certain situation in where a lady is uncomfortable, and in fact, your lordship, my client also tried to convey to the victim that she was not comfortable in the actions of the victim, lordship, and that is why, due to the actions of the victim, it triggered the PMS of my client,
All
lordship.
right,
That
just
is the
because of
contention.
the act of the deceased, your client did this. But what about the fact that she actually ran away from that particular spot?
Your Lordship, that is the contention here, that by the case of Shirali Wali Mohammed and the by case of Shrikant Anandrao Bhosle, the factors of fleeing the scene or committing the act in broad daylight do not disprove insanity in the present case, Lordship. By the above two
So that's a
precedents,
very quite viable defense for every particular sort of crime scenes like this particular matter which has been going on, that this is not unsoundness of mind, this is that. Running
in,
away eventually is something that you should have been taken into consideration, that actually points out the conduct on the accused.
indeed, Lordship, the council concedes to the fact that on the first prima facie, running away from crime scene indicates that the accused was knowing that what the crime was right or wrong. However, Lordship, that
Killing
cannot.
someone is wrong, obviously, sir. Killing someone is not right.
Indeed, Lordship, killing someone is obviously wrong, and the council submits to the fact. But Lordship, due to the PMS, my client did not know what the nature of the act she was committing was doing.
All
That
right,
is the
let's proceed to
contention
the
here.
next issue now.
Much obliged, Lordship. Lordship, moving with issue number 3 in the present case, the council will be dealing with the issue in two limbs. Firstly, that the extraction of NID data violates the right of Article 20, Clause 3, and secondly, that there were no exigent circumstances necessitating the warrantless extraction of NID data. Lordship, for the first limb of the argument, it is submitted that the case of MP Sharma versus Satish Chandra clearly held that a search authorizing the investigating agencies to search the documents maintained by the said accused attracts Article 20, Clause 3 because of the phrase to be a witness in the article. It's not merely by giving an oral evidence but also by means of production, Lordship. To be a witness, Lordship, is nothing more than to furnish an evidence, and such evidence can be furnished through a document. Coming on to this document, Lordship, it is submitted that that Section 2 Clause D of the BSA establishes that a document can be in form of electronic or any digital record. In the present case, Lordship, the NID data of Arohi constitutes absolutely as a document under the BSA, and applying the case of MP Sharma, any search or investigation into the NID data clearly infringes our Article 20 Clause 3 and thus vitiates any further proceedings against her. For the second limb of the argument, Lordship, it is contended the right to privacy is a hallowed and intrinsic part of right to life and personal liberty, and any endorsement upon the same must withstand the highest degree of constitutional scrutiny as held by the case of K.S. Puttaswamy versus Union of India. Lordship, Lordship, the council pleads 2 minutes of extension for the same, if your Lordship permit.
Yeah, please go ahead.
Much obliged, Ladyship. Lordship, the reliance on Section 12 of the DNRA is clearly misplaced, as its vague term like public interest and exigent circumstances grant arbitrary power to the executive, which is a flaw that this court cautioned in the case of Sher Singhal versus Union of India. Furthermore, Lordship, the police's actions constitutes a direct contravention of the statutory frameworks enshrined in the DNRA. Section 8 of the DNRA explicitly guarantees that every individual has a right to mental privacy and mandates that access to such inherently sensitive data requires explicit informed consent, which was not obtained in the present case, Lordship. The police made no such attempt to secure her consent, treated her data as readily available for seizure. The police's failure, Lordship, to adhere to this procedure cannot be cured by self-serving section of Section 12 of the DNRA. Now, this principle of consent, Lordship, is further fortified by the DPDP Act of 2023, whose Section 6 sets a mandatory standard that the consent must be free, specific, informed, unconditional, as well as unambiguous. Lordship, it is needless to say that the consent was not even tried to be obtained in the present case, let alone free and unconditional. The claim of exigent circumstances that the prosecution is making to justify the warrantless search is a baseless pretext, Your Lordship, because there exist no exigent circumstances in the present case. In Karnail Singh versus State of Haryana, Lordship, this court emphasized that if the police believes that there are reasons due to which a warrant cannot be obtained, then such reasons must be recorded in writing. But the Lexlandian police provided no such written justifications, and nor could they have, Your Lordship. The NID data was securely stored on encrypted cloud servers that were managed by Neuralink, which eliminated any imminent risk of destruction. The police had ample amount of 2 full days between identifying Arohi and her arrest to obtain a warrant. And the principles laid down in the case of State of Punjab versus Balbir Singh clarified that the exceptions to the warrant requirement must be strictly construed and are not applicable where the investigators have sufficient time and opportunity to obtain one. Here, the investigators clearly had 2 full days to obtain a warrant, Lordship, and this. The Article 20 Clause 3 of my client is clearly violated. If your Lordship is satisfied with the issues, the council seeks permission to go ahead with the prayers.
I have one question, Counsel. When we are talking about Article 20, Clause 3, we are specifically talking about testimonial compulsions, right? Does neural data qualify as testimonial compulsion, or is it just physical evidence?
Indeed, Lord Ladyship, the council submits the same that by the case of Selvi versus Karnataka, two things were held. Firstly, that narco analysis and brain mapping were considered. Narco analysis were clearly held to be unconstitutional, as well as, Your Ladyship, the case of K.S. Puttaswamy gave us 3 guidelines that there should be a compulsion. Should be a compulsion, and secondly, any indirect extraction of data. By the case of Selvi versus Karnataka also, the brain mapping test was also held to be unconstitutional. Lordship, this is a developing field of law of neural data, and this can be construed as a brain mapping test which is used to extract the NID data, and hence giving the it is a indirect testimony that has been extracted by my client, Lordship, even though it's not a direct testimony that is given.
Okay, please proceed.
Much obliged, Ladyship. Wherefore, in the lights of facts stated, issues raised, arguments advanced, and authorities cited, may this Honorable Supreme Court of Lexlandia be pleased to firstly hold that the SLP is maintainable. Secondly, declare that the PMS qualifies as a valid defense under Section 84 of the Lexlandian Penal Code. Thirdly, hold that the extraction of NID data violated petitioner's fundamental rights. And fourthly, declare that the undisclosed involvement of the Neurolit Private Limited violated petitioner's right to fair trial under Article 14 of the Constitution, and or are pass any order or judgment it may deem fit in the interest of justice, equity, or good conscience. All of this is most humbly and respectfully submitted. This was counsel number 2 on behalf of the petitioners. It was an honor to argue before this bench.
Let's proceed with the respondent side now.
Right, Matt. May it please this honorable court, I appear on behalf of the respondent state. Counsel seeks permission to refer to the bench collectively as your lordships.
Please do.
Much obliged to your lordships. Your lordships, I am counsel number 1, and I will be taking 9 minutes of the honorable court and will deal with 2 particular issues. Issue number 1, whether the petitioner's special leave petition is maintainable given the trial court's conclusions and the revelations surrounding Neurolytics' role. The respondent maintains that it is not. And issue number 4, whether Neurolytics' involvement in analyzing the petitioner's NID data violates her right to a fair trial under Article 14 and her autonomy over her data under the DNRA. The respondent again maintains that it does not. And the remaining issues, issues number 2 and 3, will be dealt by my co-counsel. Before I proceed to argue the matter, I seek the permission of the bench to assert the prayers that the respondent is seeking in the present matter.
No, we'll get up to the place in the later point of time. We'll just proceed with the
Sure.
argument.
Right. I seek to proceed with the arguments in that case, Your Lord.
Please.
I will start with issue number 1. At the very outset, it is my respectful submission to the Honorable Court that the petitioner's special leave petition is not maintainable under Article 136 of the Lexlandian Constitution, and I say this on 5 pointed grounds. First of all, failure by the petitioner to exhaust alternate efficacious remedies available under Section 415 of the BNSS. I will be elaborating also on the exceptional nature and limited scope of Article 136, under which the petitioner has come to this court. Further, the trial court's decision, which the respondent submits, is sound and well-reasoned. Further, no substantial question of law of general importance has been demonstrated by the petitioner in the present matter, which is the mandate of Article 136. Finally, the interference of Neurolytics alleged by the petitioner lacks merit. I'll be proceeding with the first hand of the argument, which is the failure to exhaust alternate remedy. Your Lordships, it is a well-settled principle of law that this court's jurisdiction under 136 is to be exercised only after the exhaustion of all alternate efficacious remedies available to the petitioner. In the present case, my lords, the petitioner had an adequate statutory remedy available before the High Court under Section 415 of the BNSS, which provides that appeals concerning convictions have to go to the High Court, which she chose not to pursue. By directly approaching this honorable court, she has effectively bypassed the appellate hierarchy, converting what was meant to be an exceptional remedy under 136 into an ordinary appeal. This, my lords, renders the special leave petition premature and procedurally improper at the very threshold. Second of all, on the question of exceptional nature and limited scope of Article 136, Your Lordships, Article 136 does not confer a right of appeal. It grants an extraordinary discretionary power to be exercised by the Honorable Court sparingly and in exceptional cases, which the petitioner has failed to demonstrate in their arguments before this court. The purpose of this provision, Lords, is to prevent a gross miscarriage of justice, not to provide a rehearing on facts or evidence. As repeatedly held, this court does not function as a regular court of appeal, but as a final constitutional safeguard, intervening only where there is manifest illegality, perversity, or procedural injustice. None of the grounds have been established by the petitioner before this honorable court. Further, on the question of the trial court's decision, Your Lordships, the respondents maintained that it is based on careful and balanced appreciation of evidence. It took into account the surveillance footage, placing the petitioner at the scene, the medical and neuro data records showing heightened amygdala activity, and her subsequent conduct of checking the pulse. When she found none, she panicked and fled from the crime scene, which shows that she was well aware of the wrongful nature of the action. The conviction under Section 100 of the Lexlandian Penal Code, the respondent maintains, and the sentence of 8 years are well within the statutory framework and supported by material on record. There is therefore neither perversity of reasoning nor violation of natural justice that would justify interference under Article 136 of this Honorable Court. Further, there is no substantial question of law of general importance. The petitioner's case raises no such question of law. The issues concerning the admissibility of neurodata and the scope of the PMS defense, my lords, are already well settled under the Digital Neurodata Regulation Act and the existing jurisprudence around it in Lexlandia. The DNRA clearly shows neurodata to be used in investigations if collected lawfully, so its admissibility is not under question in the present matter. And PMS has been recognized only as a mitigating factor, not as a blanket defense of unsoundness under Section 84 of the DNRA. This is merely a challenge, my lords, to factual appreciation and expert interpretation, neither of which can constitute a ground for invoking Article 136. Further, your lordships, the interference of neurolytics alleged by the petitioner lacks merit and does not warrant this Honorable Court's extraordinary jurisdiction under 136, which is reserved for grave miscarriages of justice, none of which arise here. The DNRA, when read holistically, aims to balance personal autonomy with lawful data use. Section 12 expressly permits neurodata extraction without warrant in public interest. Moreover, analogous provisions under the DPDP Act of India allow processing of personal data for legitimate state functions, including investigation and prosecution, as in the present matter. Hence, neurolytics' limited encrypted access under the neurodata pilot program was lawful and necessary for analytical development. In conclusion of this first issue, the petitioner has not exhausted alternate remedies. The impugned judgment is free from error or perversity, and no substantial question of law or grave injustice has been demonstrated by petitioner. Hence, this Honorable Court may be pleased to hold that the special leave petition is not maintainable and deserves therefore to be dismissed at the threshold. If my lords are satisfied with submission on issue number 1, the council seeks
No, I'll
permission to
just take a
proceed with
minute of yours. Are you like
Right.
admitting the fact that you took this help out from that private company to investigate or to put down the case?
The mere fact that we engage a private entity in the matter is
No,
is
did
not
you
under-
rely upon that report? Like state took the help of that report to find out or come to that conclusive stage of it or no?
Indeed,
Yes or
indeed,
no? You did, no?
indeed.
Right, proceed.
If my lords are satisfied with that submission,
Yeah, please.
may I move to? Yeah.
Counsel, I have
on
one query. Yeah, please go ahead.
yes, your ladyship.
Okay, I have one small query. You've spoken about how you could do away with the requirement of a warrant, right? But I want to understand what was the emergency at the night of the incident that you just could not obtain a judicial authorization from any court. So what was that emergency?
Right. Your ladyship, the manner of extraction was justified under, as claimed under exigent circumstances, as immediate access was necessary to prevent any sort of destruction or loss or even corruption of volatile neural data stored in the NID. Here, we're not concerned with fingerprints. We're not concerned with mere information. This was data that could be erased by the petitioner, and therefore there existed exigent circumstances.
So
And
the
also,
the petitioner had access and authority to tamper with her own neural data, which gets recorded in a different third-party private entity database.
Milords, considering the fact that the petitioner is a professional in the same area, I believe that they had the capabilities to do the same.
So you're saying that there might be loopholes in the whole system out there. That is the reason you have to like do it on that emergency basis out there.
Milords, we've taken the ground of Section 12 of the DNRA, which expressly empowers this warrantless extraction. So there was exigent circumstances where they could have destroyed the evidence, and therefore, having taken that ground, I believe it was a justified extraction.
So if they could have destroyed the same, that means the database was recorded in that third-party entity database and it could have been manipulated. So I'm assuming even after extraction, it could have been manipulated again by the third-party entity. So we basically cannot rely on this evidence. Is that what you're saying?
Not at all, not at all. My ladyship, the respondents maintain that whatever data was processed under strict supervision of the state, and therefore the assertion that it was manipulated by the private entity should not arise.
Okay, all right, please proceed.
Much obliged. My submission on the second issue is that Neurolytics' involvement in analyzing the petitioner's neurodata violates neither her right to a fair trial under Article 14 nor her autonomy under the Digital Neural Regulation Act. I will address this issue under two heads. First, I seek the permission of the bench to get a couple more minutes to be able to summarize this
please.
issue. Yes.
Please proceed.
Firstly, I'll be taking this under 2 points. First is that there is no violation of Article 14, and second of all, the DNRA has been fully complied with. Your Lordship, the engagement of Neurolytics was lawful, supervised, and done to enhance evidentiary accuracy, not to prejudice the petitioner. As held in Maneka Gandhi, Article 14 prohibits arbitrariness, not the use of private expertise. Fairness is context sensitive, and here accuracy itself furthers a sense of fairness. Further, on the question of use of private expertise, as questioned by my ladyship, courts focus on reliability, not the source of the evidence. In R.M. Malkani versus State of Maharashtra, admissibility had turned on authenticity, not on who produced the evidence. So Neurolytics' methods are scientifically validated and open to cross-examination. Further, natural justice has been preserved. The petitioner was never denied an opportunity to contest the data or question the experts in the present matter. Allegations of bias based on Neurolytics' commercial nature are merely speculative and non-factual. The judiciary, not the corporation, has the understanding to decide the question of admissibility and weight of the evidence. Further, on integrity of the adjudication, the respondents maintain has remained intact. Every step of analysis was subject to judicial scrutiny. Article 14 ensures non-arbitrariness, not disclosure of every technical detail in the matter. Hence, Neurolytics' limited supervised role by the state strengthens due process rather than it undermines it. Further, compliance with the DNRA and qualified autonomy, Your Lordships, the DNRA expressly permits lawful processing of neurodata for public interest purposes, including criminal investigations as in the present matter. Lawful processing and consent under Section 8, consent is not required where processing serves a public purpose. Once data is shared with the state, delegation to authorized processors like Neurolytics is entirely lawful. Autonomy also is not absolute. Milords, as held in case Puttaswamy, privacy may be restricted by a valid law pursuing a legitimate and proportionate aim. The purpose here, accurate adjudication, is legitimate and also proportionate. Selvi versus State of Karnataka also dealt with coerced narco tests. Here, data was voluntarily given and lawfully analyzed. On the question of proportionality, the aim was legitimate, the means were rational, and no less intrusive alternative existed. There is no evidence of unauthorized or secondary use. Because, Your Lordships, the nature of the NID requires specialized neuroanalytics infrastructure that only Neurolytics possessed under the state's authorized pilot program, the Ministry of Cognitive Technologies lacked the technical capacity to decode or analyze encrypted brainware data independently. Hence, delegation to Neurolytics under strict supervision and encryption protocols was the least intrusive and most effective means to achieve the lawful investigative objective. In conclusion, fair trial rights have remained intact, natural justice and oversight were preserved, and the DNRA safeguards were followed in both letter and spirit. Hence, Neurolytics' involvement does not violate Article 14 or the DNRA. It rather upholds scientific fairness and constitutional balance. The counsel is privileged to argue before this honorable court. With the permission of the bench, now my co-counsel will take the case for the respondents forward from here.
Counsel, I just one small question.
Yeah.
You mentioned that the third party who interpreted that data, they could be cross-examined, right? There was no issue in cross-examination.
Yes.
Right, but were they ever disclosed as an expert witness to the defense? Was that availability of cross-examination, the option of cross-examination even provided to the defense?
Milords, as claimed by the respondents, here we see how not every technical detail of who is processing the matter is required. So Article 14, the basis that they are taking under Article 136, that Article 14 was violated, it ensures non-arbitrariness. We agree to that matter, but every disclosure of technical detail in the matter is not necessary.
But this is not a technical detail as to what ma'am is asking you. This is something else.
Indeed, I concede to the fact that yes, the neurolytics his role was not revealed to that matter, but there was no deliberate attempt to hide that
So in
particular.
case if it is not revealed, then it is not a fair trial, no?
That is definitely for the court to decide that question. And my co-counsel will demonstrate further on that question.
Yes, please.
With the respectful permission of the bench, may I proceed?
Please.
May it please this honorable court. The respondent respectfully submits, Your Lordship, the law which was made to protect must not be turned into a weapon to shield the guilt. The petitioner seeks to clog the deliberate violence in the veil of medical incapacity and to condemn the lawful investigation as constitutional access. I shall be addressing the two issues, Your Lordship. The PMS does not amount to legal insanity under Section 84 of LPC, and the extraction of NID data was lawful, proportionate, and did not violate Article 20, Subclause 3 or 21. I will demonstrate that both the claim collapses under the jurisprudence and the statutory authority. Moving on towards the first issue, that PMS does not qualify as unsoundness of mind under Section 84 of LPC. My lords, Section 84 is not a medical defense, it's a legal one, as it has been clearly held in the case of Dayabai Chhaganbhai Thakkar versus State of Gujarat, that the presumption of sanity stands unless the accused proves otherwise. The burden is squarely on the defense to establish that at the time of an act, the accused was incapable of understanding the nature and wrongfulness of the act. Merely showing emotional distress or hormonal function is insufficient. Similarly, as held in the case of Bapu versus State of Rajasthan, the court held that the irritability or temporary emotional disturbance does not meet the threshold under unsoundness of mind under Section 84. Your Lordship, while the medical sciences recognizes PMS as the cause of irritability or depression, the law does not treat it as a mental disease unless it destroys the cognitive understanding. It is clearly held in the case law of Kumari Chandra versus State of Rajasthan that PMS was accepted only where there was a clinical proof of psychosis and repeated medical certification. There was a wrong corroborated evidence, including medical evidences that was provided by the doctor in this case, whereas in our case, neither of this is exist. In contrast, Your Lordship, Arohi Mehra demonstrated full awareness. She concisely picked up the cricket ball, aimed and threw at the deceased, checked his pulse, and fled upon realizing the consequences. These actions indicate knowing and purposeful act and not the cognitive incapacity, Your Lordship, not the cognitive incapacity. Further, Your Lordship, as it has been clearly rated down in the case of Surendra Mishra versus State of Rajasthan, that legal insanity arises only when the cognitive faculty is so impaired that the accused cannot distinguish right from wrong. In the present case, the evidence surveillance, NID logs, and her own conduct shows that she was fully capable of appreciating the consequences. Thus, the trial court has rightly held that the petitioner's state does not satisfy the threshold under the unsoundness of mind under Section 84, Your Lordship. Further, moving towards the next issue, the extraction of NID data does not violate Article 20, Subclause 3 or 21. My lords, Article 21 does protect the privacy, but not the absolutely. In Manika Gandhi versus Union of India and K.S. Puttaswamy, the court has laid down that any restrictions must satisfy the test of proportionality. That is, it has to have a legitimate aim, a rational nexus to that aim, necessity and balance between the intrusion and objective. Here, the legitimate aim was crime investigation and public safety. The rational nexus was the data revealed the real-time neural signals vital to determine the mens rea, and the necessity the device stored the volatile neural prone to the deletion that delay could destroy the evidence. Further, the extraction was time-bound, limited to the incident period and the least intrusive means. Further, Your Lordship, the case of Modern Dental College was a state of MP clearly states the measure is proportionate. Moving on, Your Lordship, about the exigent circumstances under the immediate action, Section 12 of DNRA allows that without warrant, exigent circumstances or public interest. Here, the exigency was real. Neural logs are dynamic and self-purging. Any delay would have meant irreversible loss to the forensic data. Therefore, Respondent Act was not arbitrary, but it was urgent, lawful, and necessary. Further, it has been a settled law in the case of R.S. Gopi Krishna Agarwal versus R.N. Sen that warrantless seizures are permissible in pressing investigation needs, provided provided statutory safeguards exist, which DNRA ensures. Further, Your Lordship, the petitioner invokes self-incrimination, but the principle is misplaced. Clearly, in the case of V.S. Kuttan Pillai versus Ramakrishnan, the Supreme Court clarified that the Article 20, subclause 3 protects the compelled testimony and not the passive evidence. The NID logs were pre-existing, automatically recorded and collected from the third-party custodian. This analogs retrieving CCTV footages or phone records and not a compelling confession, Your Lordship. Even in the case of Selvi versus State of Karnataka, it has clearly distinguished between the active extraction like narcoanalysis and passive retrieval of data. Here, ROE was never subjected to any real-time interrogation. Only her stored logs were examined. Hence, there was no testimonial compulsion. Point to be noted, Your Lordship. Further, moving on, in the interest of public and statutory compliance, the action was grounded in a statutory mandate and public interest. Section 8 and 12 of DNRA permit the use of such data to prevent the tampering in an investigation. Moreover, as clearly held in the case of Supreme Court of India versus Subhash Chandra Agarwal, public interest must include moral and material welfare of the society, which investigation clearly served in this case, Your Lordship. Thus, the respondent acted under a lawful authority and not arbitrary. My Lordship, the privacy is not a right to hide the wrongdoing, but a freedom to live with dignity. The petitioner seeks to convert the constitutional shield into the tools of invasion. My lords, the law cannot prevail the secrecy over accountability. The state has acted within the power, proportionality, lawfully and transparently to preserve the justice and public safety. Therefore, Your Lordship, we humbly pray to this honorable court that PMS doesn't amount to the unsoundness of mind under Section 84, and extraction of NID data was lawful, proportionate, and non-testimonial. With the permission of the bench, may I proceed towards the prayer?
Now tell me one thing,
Yes,
like you just mentioned that you only examined a particular mind or log, whatever, of the accused. Did you examine the deceased mind to understand his dynamics at the time when he pointed out certain things to the accused out there?
My lords, the NID data was important to show the mens rea that there was a guilty intention.
No, that is fine. But did you examine the deceased mind also?
My lordship, the examination of the deceased mind was not possible. It has not been clearly stated to the state.
No, but the logs might be recorded in some third-party entity, or probably with you over the passage of time.
Absolutely, Your Lordship. But it has not been in the contention that there was a requirement of the respondent data. It has never been brought by the petitioners as well that there was any harm.
No, that is fine. It's up to the state to examine the scene of events or scene of crimes, not the petitioner.
Sorry, Your Lordship, such information has not been shared with the state.
Okay.
With the permission of the bench, may I please forward towards the prayer?
Yeah, please.
My lords, the respondents here pray for that petitioner's SLP is not maintainable. Second, the PMS does not qualify as a sound defense of unsoundness of mind under Section 84. And the extraction of petitioner's NID data to infringe her constitutional right under privacy under Article 21 and protection from self-incrimination under Article 20, subclause 3. 4. The neurolytics involvement in analyzing the petitioner's NID data do not violate her right to fair trial under Article 14 and the Constitution, her autonomy over her data under the DNRA. May this please this court to declare any further, to grant any further interest in the equity of justice and good consent. It was an honor to argue before the respectful bench. That's all, Your Honor.
Anything in rejoinder of the petitioner side wants to say?
If Your Lordship's permit, the council would like to go ahead with the rebuttals.
We'll just give you a minute or so, because then there will be some rejoinders and so.
A minute, Lordship. Much obliged. Lordships may kindly allow me to go a little faster as there are a lot of points which the council needs to. Much obliged.
Please.
Lordships, to begin with the rebuttals, my learned opposing counsel clearly stated the requirement for exhaustion of alternate remedies. But Lordships, the counsel submits the case of Sanvat Singh versus the state of Rajasthan, wherein the Honorable Supreme Court provided two clear exceptions wherein this doctrine of exhaustion of alternate remedies can be excused. Firstly, when there are grave injustices caused due to the lower court's judgment, and secondly, where the question involves a substantial question of public interest. Lordships, both these requirements have duly been met in the instant case, and hence the doctrine of exhaustion of alternate remedies is well excused in the present matter. Lordships, secondly, the source of the NID data was not known. Lordships, the chain of custody requirements were not fulfilled. There were no cross-examination opportunities provided to the petitioners at the trial stage. Lordships, all these clearly reflect the perverse nature of the trial court's findings, which my learned opposing counsel did not bring forth before this honorable court's attention. Lordships, furthermore, the DPDP Act, the counsel concedes to the fact that allows for processing of personal data. But Lordship, the said act does not in any manner allow for the government to give the said neural data to any private third party to process the same. Lordships, which is the contention of the petitioners in the instant case. Furthermore, Lordships, the allegation regarding the petitioner having the opportunity to tamper the neural data, Lordships, it is pertinent to mention that the said neural data was stored on the encrypted cloud servers of a private third party, which is Neuralink Corporation. Lordships, if the petitioner had the opportunity to tamper with such data, Lordships, the state can well in every case bring forth the Section 12 exception before this honorable court and claim that the petitioner in such a case has the opportunity to tamper with such data, which is completely unfounded in law. Lordships, furthermore, the expert evidence, my learning opposing counsel said that is not a necessary component in this regard. Lordships, I humbly submit that the expert evidence is rather important to cross-examine at the trial stage itself. Lordships, one last submission, if your Lordships permit. Indeed, Lordships, my learned opposing counsel bring forth the case of Dayabai Chhaganbhai Thakkar versus the state of Gujarat to draw a distinction between medical insanity and legal insanity. Lordships, it is humbly submitted that the same case drew a distinction between permanent insanity and temporary insanity as well, which my learned opposing counsel clearly overlooked. Lordships, had the distinction been drawn, the PMS defense could have well fallen within the ambit of temporary insanity in itself. Furthermore, Lordships, the bias of NID data of the deceased was not examined, as well pointed out by your Lordships, and is well documented on page 4 of the fact sheet, Lordships. If your Lordships may kindly have the fact sheet, it clearly states that the NID data of the deceased was not taken by the investigating agencies, which leads to potential biases. That is all for the rebuttals, Lordships.
I now call the respondents for rebuttal. You have 2 minutes.
Right. Much obliged. Your Lordships, the petitioner's submissions before this honorable court are untenable both on facts and law. I say this on 4 pointed issues. Issue number 1, firstly, the SLP itself is not maintainable as the petitioner has bypassed efficacious remedies under Section 374 and 415 of the BNSS. The Lexlanian precedents have already settled this position. The reliance on R.K. Jain versus police and Mohammad Hussain versus state is misplaced. Both are distinguishable on facts. Moreover, Neurolytics' involvement is squarely sanctioned under the DNRA and the DPDP Act. No material evidence was suppressed. The chain of custody was also maintained, and the petitioner was granted full opportunity to challenge the neurodata report, disclosing premeditated aggression at the trial stage, which they deliberately did not. Secondly, PMS cannot operate as a blanket defense under Section 4 of the IPC. No medical or circumstantial evidence demonstrates unsoundness of mind at the crucial moment. Her conduct, checking the victim's pulse and fleeing, reveals awareness and control. Even under Kumari Chandra and Kumari Chandra, PMS requires clear medical corroboration, which is absent in the present matter. Hence, no cognitive impairment has also been demonstrated by the petitioner, and the plea therefore fails. On issue number 3, collection of NID data satisfies the proportionality test. The accused was not compelled to be a witness as clarified under V.S. Kutan Pillai. The public interest exception under the DPDP Act validly authorizes such collection without consent for state purposes. The petitioner had every opportunity during the trial to question the report, its source, method, or reliability, but failed to do so at the trial stage. Given the volatile nature of neural data, immediate extraction was justified. Selvi also is, in the present matter, inapplicable as no coercive brain mapping was conducted in the present matter. Lastly, on issue number 4, due process was followed. The petitioner was given adequate opportunity to examine the evidence, which they did not. Consent was not required as public interest and statutory mandate under DNRA overrided. Hence, Your Lordship, the procedure adopted was lawful, proportionate, and constitutionally valid. Much obliged, Your Lordship.
There seems to have been a lot of selective investigation in this entire matter, which cannot form the basis of any conviction. So we are acquitting Arohi Mehra of all charges. Right? The third party who's interpreted the data was undisclosed, and there was no possibility of giving an opportunity to the defense for cross-examination, and hence the entire NID logs that you've relied upon are being treated as legally inadmissible.
So we are going with the petitioner set of arguments today.
Thank you, sir.
See, one thing I want to point out, it's a Sunday, like don't spoil your Sundays. You all of them like actually performed in a way better perform up there. And it's something like winning and losing is a part of the game, even if eventually you get into litigation of law. So there are certain things which you actually need to take care. Like just spend that extra 1 minute or extra 1 hour in the preparation so that at least you know you can be your own critic. Don't go by whatever other people do say. Like we also lose, ma'am also wins. It's a part of the process. So like don't take it personally. It's something that it's only that the composition is such that only one side can go to the final stuff there. But all of you actually, I'm very proud of the fact that you all of the people actually whom we were today listening to are actually doing good, and the profession is in the safe hands. At least I could say that. And you actually won because of the fact that other lawyers sitting at home enjoying their Sunday, and you're actually cultivating your resources out there. So it's quite good out there. So all the best for the future out there now.
Also, the respondents, you had a tough case. There were a lot of serious lapses as per the facts, and you've been able to answer all our queries in great detail and with good research. So, really well done.
See, one thing I want to point out, just be very cautious about the court ethics because eventually that is going to be the standard for your name in the market in the long run. So be ethically very profound out there. So that is all. All the best. Have a great Sunday. Watch that particular India-Australia match today also. Go ahead.
Thank you so much,
All the
sir.
best.
Thank you. Thank you, sir.
Thank you, sir. Thank you.
Thank you.
Thank you, honorable judges, for your valuable feedback and time.